presentation will start with a little bit of a background on HIPAA de-identification, just in case we want to just level set and make sure everybody's on the same page with respect to what's already in the law. And then we'll talk a bit about sort of where we see some concerns that might need to be addressed and why we think now might be the right time to start addressing them, or at least have a proposal ready to respond to policymakers' interest. And then we'll actually spend the bulk of the webinar really talking about some of the proposals that we have begun discussing with some stakeholders. As Cal had mentioned, we pulled together some folks at a recent workshop and started a discussion that is really still in progress. We have not made definitive decisions about what we're going to support, and we ideally actually would like to do so in a collaborative way with other stakeholders. So this webinar, in many respects, is very well timed because it allows me, perhaps through your questions, and you can feel free to do some comments too if you'd like, to continue to be able to refine what we're working on, and really the overall goal is to drive to a proposed set of policies that will bring us forward, and hence the title of the webinar is Potential Paths Forward. So with that, I'll advance to this. This is my standard slide for those of you who are not familiar with the Health Privacy Project at CDT. CDT is a nonprofit public interest education and advocacy organization primarily located in Washington, D.C. in the U.S., although we do also have an office out in San Francisco. And our goal really is, to borrow the Canadian term, is to achieve privacy by design in the healthcare space. Privacy and security policy solutions really need to be workable because we have a lot of data flow needs in the healthcare space. And the privacy and security policy solutions we come up with should really enable the data sharing that we want to encourage and build public trust in health data infrastructure. And that's really the theory on which we try to approach all of these questions, is privacy policy that works, that where privacy is not necessarily the end point, but supports the end goals of the outcomes that we're trying to achieve with respect to data. So again, little level setting on HIPAA policy on de-identification. De-identified data, when we use that term, and certainly when we use it in this webinar, we mean data that meets the standards under HIPAA, the Health Insurance Portability and Accountability Act regulations for de-identification. And when data meets this standard, it is not considered to be PHI, which is protected health information, identifiable health information, and then it's largely not regulated by HIPAA or pretty much any other law, at least not comprehensively. And the legal standard for de-identification is no reasonable basis to believe the data can be used to identify an individual. And the regulations under HIPAA really set out two methods for accomplishing de-identification. One is a statistical method, which requires that someone with statistical expertise determines that the risk is very small, that the information either on its own or in combination with other reasonably available information could be used by the anticipated recipient of the data to identify an individual. And then there is the safe harbor method, which requires the removal of 18 specific data elements or data categories, and the data holder must not have actual knowledge that the data, either alone or in combination with other data, could be used to identify an individual. And there's the reference to the regulation there for those of you who are not familiar with those 18 categories. It is permissible for entities to assign a code to allow de-identified data to be later re-identified, again, as long as you don't share that code. Because clearly if you did, with the data, arguably it's not de-identified. So what are some of the de-identification policy challenges? Well, in our view, and we didn't invent this, the risk of re-identification is contextual. what other data does the data recipient have access to that they might be able to use to re-identify individuals in the data set, and what is their motivation to re-identify and potentially use that data inappropriately. And we have had persistent concerns that the safe harbor approach, which says if you remove these 18 specific categories and as long as you don't have actual knowledge that the data can be re-identified, you're home free. That really assumes that you've got a static environment and draws these automatic conclusions that the data raises a very small risk of re-identification without the consideration of this context. Additional policy challenges. Ensuring this very small risk of re-identification, again, particularly through the safe harbor standard, where we're going to beat up quite a bit on safe harbor today, could get more difficult over time due to the increased availability of data. Of course, the statistical method for de-identification arguably addresses some of these challenges more directly and is more contextual in nature, but how robust it is going to depend on the quality of the statistical analysis. And we don't, at this stage, have any formal or even informal, to the best of my knowledge, processes in place for vetting or accrediting statisticians who do this work, although my understanding is there's not actually all that many of them who do this on a routine basis, at least independently. Again, de-identification, the standard is a very small risk. The standard is not no risk. No risk is impossible to achieve and isn't required to be achieved by the regulations. And so the fact that we don't regulate it at all when it achieves de-identification status is of concern to us. In our view, even where there is minimal risk, there ought to be some regulation attached to the risk that does exist. And then, of course, concerns about uses of de-identified data and the robustness of de-identification methodologies appears to be increasing. And recently, the U.S. Supreme Court heard a case on a Vermont statute that regulated the use of HIPAA de-identified data, and a number of these concerns were raised by the state of Vermont in the case, and as well as a number of individuals and organizations that submitted amicus briefs. And a number of people were very unsatisfied with that opinion because which struck down the Vermont statute that regulated marketing uses of de-identified data. For those of you who are not familiar with it, a number of individuals and organizations were dismayed that the court missed an opportunity or decided not to take advantage of a potential opportunity to address issues related directly to HIPAA de-identification. And so there's a little bit of a simmering fire underneath this issue. I would say it's not to the point where it's exploding yet, but in our view, that actually puts us in a much better position than we usually are in policy circles, where we're having to put out immediate fires, and there is a lot of passion associated with this issue. But we have the advantage at this moment of being able to try to think through some thoughtful policy versus sort of having to respond to policies that are sort of generated in the heat of the moment. So notwithstanding the fact that we do have these concerns about the HIPAA de-identification standard, we also firmly believe that data that is rendered less identifiable is less of a privacy risk. So even if there are limits to whether true de-identification can always consistently be achieved, this does not mean that all data present equal risk. And it's been of concern to us that some organizations and individuals have strongly suggested, if not outright stated, that the state of de-identification is so broken that essentially all data present equal risk, and we do not think that that is the case. De-identifying or removing identifiers from data or shielding identity through the use of technology provides additional protections for confidentiality and still preserves the utility of the data for a range of important purposes. And in addition, we think that other requirements in HIPAA, specifically the minimum necessary requirement, arguably applies to data identifiability, although we concede that it has never been specifically interpreted by the regulators here in the U.S. to apply to data identifiability. But if in fact we're right about that, then you should be using the least identifiable data needed in order to accomplish your purpose for accessing the data. So, back to a topic I already started to introduce. Is it time to strengthen our de-identification policies? And our view about this is yes. Again, much better to try to think through these things now than in the heat of the moment. Concerns about de-identification based on misinformation, and I'm not suggesting that people are trying to be deliberately misinformative. I think I just invented a word. But I do think that there is a lot of passion around these issues that sometimes can lead to very bad policy. We sometimes call this policy based on politics versus substance, and really that just never happens, does it? It happens all the time. You can't completely get it out. You can't completely avoid it, but I like the moment that we're in right now to be able to think through these things with some clear heads. We do think that there are gaps, both with respect to the robustness of the standards and the protections for the minimal risk that does get raised that could be fixed. We don't think it needs a significant overhaul. In our view, though, we would need an approach that has some consistent threads with proposed policy approaches to anonymization on the internet and some of the work that's being done on targeted behavioral advertising and do not track, which are issues that CDT also works on. So, and to the extent that we have health data that isn't just being shared in the HIPAA sphere and is in fact being shared by other parties not covered by HIPAA, largely in the consumer space, consumers we think are often better served when the policy has at least some consistent threads. It doesn't necessarily have to be wholly consistent, but that is certainly our interest. Of course, there's a contrary view. We don't have any real hard evidence that, in fact, the system is broken. The de-identification methodologies that are currently used, instances of re-identification where, in fact, the data sets meet the de-identification standard are extremely rare. And as far as we can tell, the companies that are active in this space, their motives to re-identify, especially when re-identification is costly and could be damaging to their business reputation, are obviously in question. In other words, we're not sure they have a lot of motivation to re-identify when re-identification is actually hard and often can be expensive. Again, when you're talking about a properly de-identified data set that meets the standard of raising very low risk of re-identification. And opening this issue could still result in bad policy. Again, this sort of politics, is it politics versus substance? Anytime you sort of open up an issue, you run the risk that it won't come out exactly in the way that you hope that it will. We still think it's worth doing, if only to have a set of vetted and ideally consensus-based policy proposals in our hip pocket, so that if, in fact, there is a moment in time when the policymakers, in fact, do want to address this, we are ready. The work that we have done on this issue really began back in 2008 when we held an initial workshop on HIPAA de-identification with a number of stakeholders. I see a few names on the list of some folks who were at that early workshop and also at the most recent workshop that we held. And we did a white paper on some potential policy solutions that were in their very infancy and were really just ideas that really generated out of that initial workshop. And we released that paper in 2009, and then sort of didn't really do much follow-up on it beyond that. And then I mean, really, quite frankly, it was the Sorrell case and the heated debate around it that really motivated us to sort of open up that set of policy proposals that we had initially floated back in 2009 and say, let's really start drilling down on some of these and find out which ones really have some merit and try to be more specific about what it is that we think is needed in this space. And that was the purpose of the follow-up workshop that we held in October. And here are the 4 areas that we really focused on in terms of potential policy solutions. And again, they have their roots in the initial workshop that we did in the initial paper, but I think they're also tied very closely to some of the concerns that have been raised by thought leaders in this space, that were raised in amicus briefs that were filed in the Sorrell case, and that is dealing with the potential for re-identification. Even if we don't have a lot of hard evidence that it's actually happening, the fact that it can happen because we don't really have any legal prohibitions against it, is a potential barrier to moving forward. And so there are certainly a number of ways to deal with this. You could try to enact a statutory prohibition or require contractual commitments not to re-identify from those who receive de-identified data. You can have hybrid models of this. There are, we're not the only people thinking about this and how you would structure this. Just to give you an example, I see Bob Gelman is one of the participants. He has done some writing on this and has really thought through in some even greater level of detail what a sort of mixed contractual statutory scheme would look like that would have a strong prohibition against re-identification and allow parties to set some boundaries about how de-identified data can be used. And we're certainly looking at that proposal quite seriously and may in fact incorporate some elements of it into the work that we're doing. Assuring robustness of de-identification methodologies. Again, the safe harbor, people like it because it's easy, but a lot of questions have been raised about it, and how do we address that? Would it be enough, in fact, just to have the prohibition against re-identification and worry less about the robustness of the methodologies? Maybe. That's something to think about. As far as the statistical method is concerned, this gets back to the issue that I raised earlier in the webinar, which is, do we trust all the statisticians who are doing this work? And is there anybody independently vetting it, particularly when it's being done internally by the companies versus, folks who do it independently and therefore would need to be, I guess arguably would need to be doing it well in order for somebody to hire them. Reasonable security safeguards that are commensurate with the minimal risk to privacy that this data, if it's properly de-identified, should raise. And then the last issue is greater public transparency about de-identified data uses, which may be the toughest of all of the issues, and the one that we had the least amount of time to spend on at our workshop. So let's dive in to these areas in a little bit more detail. Prohibiting re-identification, again, via statute or contract, or quite frankly, you could do a combination of the two. I expected at our workshop for this one to be universally supported, again, especially if you're talking about companies having a vested interest in being able to continue to mine and utilize de-identified data where their motivation for re-identification is arguably very low, why wouldn't a prohibition on re-identification get a lot of widespread support and pretty much be a slam dunk? Well, I was kind of surprised that people raised some concerns at the workshop. Not around the concept of making re-identification sort of a bad thing and disfavored, if not prohibited in some way. It was more about what are the consequences of prohibiting something, some unintended consequences that might have a negative impact on the availability of de-identified data. And the ability for us to continually test de-identification methodologies to make sure that they're robust. So, folks said, look, we don't have any evidence that, in fact, widespread re-identification is occurring, and trying to craft a workable protection could actually do more harm than good. We would probably need to build in some exceptions to allow individuals to test the robustness of de-identified data sets. Some of the important policy questions that have arisen in this space have come because of the work of leading academics in sort of looking at data that was supposedly de-identified and being able to demonstrate that re-identification was either possible or that there was a higher risk than presupposed of re-identification. And in addition, in the healthcare space, there is often a legitimate need to re-identify individuals in order to alert them of something that is important pertaining to their health. Now, of course, you can craft exceptions in the law or give regulators the authority to craft exceptions, but it becomes difficult to do this accurately for anybody who's done statutory drafting. It's easier said than done sometimes. And another one is that fears of liability, either real or perceived, could make de-identification more expensive, really through overly conservative behavior. So if there are harsh penalties for re-identification, you might be very reluctant to handle de-identified data or to be in the business of combining de-identified data sets for fear that you could inadvertently trigger the prohibition. This was a concern raised by at least a few people at our workshop. And then another one that it's just occurring to me that I forgot to add to the list is the notion that prohibiting something doesn't make it disappear, it just forces it underground, where it would be harder to detect. Of course, we don't have very much evidence that it's actually happening today when we don't have those prohibitions in place. So, a point worth talking about more. On the pro side, and we actually are still, we still think that some sort of re-identification control or prohibition is worth pursuing, notwithstanding some of the cons. We are still at the phase where we think that they are manageable or can be dealt with. Taking the prospect of re-identification really off the table could increase public confidence in de-identification and uses of de-identified data. It arguably reduces the motivation to re-identify to the extent that it is out there, which then reduces re-identification risk. So we find ourselves still on the pro side of this question, but admit that it's a little bit thornier of an issue than we initially thought. Second category is in the area of assuring robustness of HIPAA de-identification methodologies. In general, there was high degree of support for this at the recent workshop, but the trick is really figuring out the details. And so some promising ideas that we are pursuing is to require HHS, and there was strong support for having them be supported by an organization with a little bit more technical experience like NIST, to establish a standard or standards, something beyond very low risk, something a little bit more specific to drive at, for acceptable risk of re-identification, that really all de-identification techniques, whether safe harbor or statistical, must meet. It should be subject to review every X years. Not sure what that should be, but obviously we don't want to be in the situation we're in now, where safe harbor gets created in about 2002, implemented in 2003, and we don't ever touch it again, regardless of what else is happening in the world. HHS, in fact, would then be required to evaluate the current safe harbor methodology against this, it says percentage, so it's really against the standard or standards every so many years. It may be that we need different standards depending on how the data is released. For example, public use data sets versus those that are going to a trusted third party. But here was the idea that came out of the workshop that we really had not thought of and is not in our 2009 paper, and that is HHS should actually add methodologies to Safe Harbor to provide other viable and effective options for de-identification. There was some discussion about whether Safe Harbor, because it really doesn't take context into account, that it should just be gotten rid of, and that we should go to an all statistical methodology world of de-identification. But there was really strong pushback on that because there needs to be a relatively easy yet reliable way for this to be done. And Safe Harbor, because it's so specific and because it in fact is a safe harbor, and without question, if you use the methodology, you have de-identified sufficiently to be considered to meet the standard, that it's highly valuable. It's a highly valuable methodology, but rather than just use the methodology that we have there today, perhaps we should add and have a menu of methodologies that meet safe harbor status, or a safe harbor pot of options that people can choose from. Other ideas. We're really beating up on the safe harbor today, even though we do intend to keep the concept of safe harbor, at least at this stage of our discussions. But the current, again, because of the concerns about the current safe harbor methodology, notwithstanding that we don't have a lot of hard evidence that it's being routinely cracked and people are being re-identified from safe harbor de-identified data sets, many people have written about its weaknesses, its potential weaknesses, and so perhaps we ought to limit when it can be used in order to better manage re-identification risk. And some of the ideas that have come forth, and we have borrowed heavily from leading thinkers in this space, it really shouldn't be used if the data set in question is not a random sample of here we say the U.S. population, since we're talking about a U.S. law. It shouldn't be able to be used when certain fields that are highly susceptible, sorry about that, susceptible to re-identification are present, such as genetic data. One could argue that already needs to come out of the safe harbor, but in case it's not clear, should be genetic data. Longitudinal data, which is more data fields about a person, therefore potentially more re-identification risk. ICD diagnosis codes and free text notes. None of the latter two are not categorically required to be excluded from the current safe harbor methodology, and could in fact, particularly as we're moving to coding standards that are much more specific and narrow, could actually be introducing greater re-identification risk. And particularly as we move in the U.S. to greater use of EHRs, electronic EHRs, where there is going to be free text notes that might be made available, this could have information in it that is more detailed and more susceptible to re-identification. It shouldn't be the sole de-identification methodology if the information is going to be made publicly available. Certainly, Safe Harbor today doesn't require consideration of context beyond if you have actual knowledge that the recipient could re-identify. If you've got a public use data set, you have no way of even knowing what other information the recipient could have access to. Of course, if you are going to place some limits around the use of the Safe Harbor, how do you deal essentially with legacy Safe Harbor data sets? Are we in a circumstance where we really just need to apply this prospectively, and we won't really be able to do any retrospective look backs? I'm not sure of the answer to that question. Here's some more promising ideas that came out of the workshop, or that we are beginning to talk about in some more detail. creating an objective vetting process for entities using statistical methodologies or a combination of safe harbor and statistical methods. And this could be a certification process or recognition of centers of excellence. And the centers of excellence idea was something that we had floated in our 2009 paper, but we didn't really, we said more details will need to be fleshed out if this is an idea worth pursuing. We do think it's an idea worth pursuing, but there are a number of key questions to resolve. One would be, who's going to do the vetting? And, I wouldn't say there was consensus at the workshop, but there was, people seem to be leaning on the side to government as a possible neutral choice, but concerns were raised about whether they have sufficient expertise. Could they develop such expertise? We also happen to be here in the U.S. in an era where people don't trust government. Oh, not all of us, but some people don't trust government as much as they used to, and so maybe there's a sort of hybrid public-private solution that might be more politically palatable. But on the whole, certainly in terms of it being a neutral arbiter and not having a vested commercial interest, government is at this point the leading candidate for doing this. I did list here on the slide a couple of private sector processes that one could argue work reasonably well in the accreditation space in the United States, the National Committee for Quality Assurance and the Joint Commission that accredits hospital organizations. I don't think either one of those processes is perfect, but there's a fair degree of reliance on both of them from a policy-making standpoint. So they have achieved some degree of trust over time, and is that something that we can create in this space? And if we were to do this, what would be the incentive or reward for achieving either certification or Center of Excellence status? And one idea is safe harbor. If you are a Center of Excellence, your methodologies are safe harbor. If you use a statistician who is accredited or who has been deemed to be a Center of Excellence or be operating a Center of Excellence, you have safe harbor status. So again, we are still very much in the mindset of discussing these issues, but we think they are worth further exploration. Reasonable security safeguards was our third category. Workshop participants seem to agree, although we had these last two discussions after lunch, and so people might have just sort of been nodding their heads because they were tired. But I think, again, if the data raises minimal risk, even it doesn't raise no risk, so there ought to be some security protections that are commensurate with the risk raised by the data. But what do reasonable safeguards look like? Because we don't really have any good examples today. When data is de-identified, it's not subject to regulation under HIPAA, and that includes the security rule. So we do know that the office within HHS that regulates human subjects research that is federally funded recently, I said recently proposed, we could call it wasn't part of an actual proposed rulemaking, so maybe we should say they recently floated the idea for public comment that the minimum security standard would be a commitment not to re-identify. I'm not sure people who wear security hats for a living would think that that's really a security protection, but nevertheless, that's the minimum that they floated for public comment in an advance notice of proposed rulemaking on the common rule, which again governs most federally funded healthcare research, federal funding from the U.S. government. Would you require more for safe harbor only de-identified data sets? And would the conclusion to that answer change if we in fact enlarge the safe harbor to include other methodologies than the current one? Maybe we would apply it only to the current one. Again, we don't have any evidence at this point that they are more risky. Or maybe not no evidence, but we have little evidence that we're aware of. And how would we police this for public use data sets, which frequently are de-identified because the source of the data needs to de-identify it in order to make it publicly available? It's assuming you have a source of data that's covered by HIPAA, which not all the releasers of public use data sets are covered by HIPAA, and that was a significant source of conversation at the workshop, that the public use data sets that are often introduced by states are not necessarily required to be covered by HIPAA, so they in fact might not meet HIPAA de-identification standards, which is another issue to spend some time discussing. And then the last issue that we considered, and then this one was, first of all, it's a hard one, and it was also the one that we took up at the end of the day, and so there really wasn't sufficient time to really vet this more thoroughly. But people at our workshop, at least, again, those who were, we still had about 3/4 of the room left after lunch, all seemed to agree that greater public transparency, particularly regarding the beneficial uses of de-identified data, would be helpful from a public policy standpoint. But it's very hard to reach the public. Just ask somebody who's in the business of advertising. Getting people's attention and getting them to understand what's going on at a relevant moment in time when they're likely to be interested in receiving the information is hard to do. Ideally, this is not just about all the beneficial uses of de-identified data from a public health and population health perspective, although there certainly are many examples of that. The idea is transparency about how de-identified data is used, including for commercial purposes. So it's not the sort of mystery black box that it is today. And it's our theory that greater public transparency, debunking the myths and being honest with people about what's going on can lead to greater public acceptance. Of course, it might also lead to people raising concerns and wanting to regulate those uses with which they do not agree. And that's the last bullet on this slide, and I think that's really quite the challenge. Dealing with data uses that may be objectionable to some, either for moral or religious reasons or for policy reasons. We talked a little bit about whether, you give people a right to be allowed to opt in or be allowed to opt out of having their de-identified data used either across the board or for certain purposes. A number of researchers strongly believe that this could introduce bias into research. Others sort of feel as though it's manageable, again, depending on the type of research that you're doing. Certainly, the Sorrell case is an example of legislature disapproving of a particular use of de-identified data and attempting to regulate it. Of course, the Supreme Court found that particular statute, which was focused on prohibiting marketing uses of patient de-identified but prescriber identified data, was a violation of the free speech rights of companies. Advertising is essentially commercial free speech, protected under the First Amendment. Some question about whether IRBs, which approve research in academic institutions doing federally funded human subjects research, which includes research on data, is there a role that they could play here, even when the data is not identifiable, in terms of sort of vetting the potential uses of data and whether they are generally acceptable or not? Certainly that suggestion flies in the face. It is contrary to the direction that HHS has historically gone and appears to be continuing to go in, which is when the data is not identifiable, research using it is not required to be reviewed by an IRB, nor is individual consent required. So, clearly this is really not territory that hasn't really been thought through very thoroughly in the past, and so it's very new, and we are eager for some creative thinking on this, and trying to do some of it ourselves, of course, but we are open to suggestions. I'm about to close, and and we are on time, so we have plenty of time for questions. This last slide, again, provides the link to our previous white paper on this topic. We essentially did two shorter versions. If you like the not to read so much paper, we did what's called a policy post, which is essentially a truncated version of our paper, and then in iHealthBeat we published an even shorter version of the policy post. And then there's my contact information for questions, but we're going to have a question period following this webinar, and I'm very eager to hear your thoughts and questions, and again, very much appreciate the opportunity to present this material to all of you.
Great. Well, thank you very much, Deven. So for the folks on the line, you can start typing in your questions now. You should see the text box appearing on your screen. While we're waiting, I'll ask the first one. And you mentioned...
Oh, no, your questions are really hard.
No, this is really easy. It should only take a few seconds to respond to this one. You mentioned consistency with Internet, and I was just with Internet privacy and behavioral targeting and so on. Can you just give us a brief view on how the identification is viewed in the Internet world, and whether there's anything that can be learned from the healthcare sector?
Well, okay, I'll try, and it's a complicated set of issues, so with full caveat that this is a truncated explanation. But basically, on the Internet, an IP address is, which would be an identifier in the HIPAA world, is considered, because it's a pseudonym, and what the advertisers know is your IP address, but they don't know that that IP address necessarily belongs to Deven McGraw. But they want to be able to know consistently where that IP address goes on the web so that they can serve advertisements to me that are more likely to be something that I would be interested in learning more about or purchasing. So it is, the IP address is used to track people on Internet sites in order to more effectively advertise to them. And in many respects, we at CDT believe there are strong privacy implications to this. More and more people are aware of it now because there's been, some fairly extensive media reporting on it. But it's becoming more obvious to folks. When you're when you're on your third website and you're logging onto your email address and you see the ad for something that you were, that's tied very closely to a search that you were just doing. I think more and more people are aware of it, but it bothers people. And to the extent that it creates a disincentive for people to use the Internet, we think that there ought to be some regulation. And historically, with respect to use of personal information for marketing purposes, we have in the health space advocated for people to have the right to opt in. And our position on the Internet side is to say, well, you should at least be able to opt out of being targeted for non-sensitive data. And when sensitive data like health data is involved, you should have the right to opt in. And obviously this is not something that some of the advertisers are terribly keen on. And advertising supports a free Internet, so there's a sort of a delicate policy balance here. Where that intersects in the health space is the fact that we often need to get a longitudinal picture of somebody in a de-identified way for health services research purposes. So we at CDT, of course, have struggled to think about, obviously there's a distinction between marketing and research, but drawing that line in healthcare is often hard because the motives of healthcare companies are often mixed in a private market healthcare system. You make money by making people better. I don't know. So in other words, if we are looking at policy that deals with anonymized or pseudonymized data, saying I'm not. We want it to be consistent. I've said that already. Whether there's anything that the internet space can learn from, standards, which the internet space doesn't have from a legal standpoint. They are largely trying to follow industry set standards, and it hasn't worked all that well in our view. Having some legally cognizable and accountable standards certainly is a lesson to be learned. But if you take the IP address off the table, which you'd have to in order for it to meet the safe harbor, I think it'll be very hard for the advertisers to do what they want to do, which is to find out what it is you're interested in so they can serve you ads that you're more likely to be interested in. So it's not. It needs more. It needs more thinking, and that's exactly what we're doing. Because it's quite complicated, and the motivations in the different spheres are quite different. And so I just took way more than 2 minutes to answer that question, but I hope people understand more the kind of intersection of the issues and how there's both similarities and differences that need to be accounted for in policy.
Great, thank you. I see some questions are coming in, so. I
see. Okay. Isn't the limited data set really the same thing as the contractual agreement and thus an existing solution? It is. So a limited data set, which requires 16 of the 18 categories of information to be removed, requires a data use agreement before it can be released. And in the data use agreement, it has to set forth the permitted uses of the data, and it has to have a prohibition on re-identification. So that is the model for a contractual solution. But it depends, if you're sort of solely relying on a contractual solution, you really have to, the impetus is on the contracting parties to enforce it largely. I mean, in the HIPAA context, if you're a covered entity and you enter into limited data set agreements and you don't police them, you could get into some trouble. If you're a covered entity and you're a limited data set recipient and you violate the terms of your data use agreement, you can also get in trouble. If you're not in the HIPAA coverage sphere and you violate a limited data use agreement, they don't have the Office for Civil Rights, which has jurisdiction over HIPAA, doesn't have any jurisdiction to go after you. So there's a bit of a missing piece, but it's definitely a model. So the next question is, I was surprised to see ICD codes included among the data elements for which safe harbor standards might not be appropriate. It is difficult to imagine that there would be much utility in most administrative data sources without such codes being allowable. It's a really good point, Dan. I think if we can think, so we didn't come up with this idea that ICD codes were, potentially make data more subject to re-identification. And I agree, I can understand the concern there, and that's why we listed it as a policy proposal. But clearly, to require it to be removed in order for carte blanche, in order for safe harbor status to apply, might not be the right approach, because we would be cutting off claims data sources. So it's a very good point, and it's one worth thinking about. But again, I think the underlying goal that we're trying to meet here is thinking about the categories of data that currently don't have to be stripped out of a safe harbor data set based on the current methodology, but which make data more susceptible to re-identification. And what do we do about those? Is it that you prohibit their inclusion, or if they are included, maybe there are some additional protections that have to be followed, and maybe, again, some sort of prohibition on re-identification may be enough to resolve that. It's a really good point. I only had two.
Well, I have another quick one. Is there any understanding on when HHS may produce new guidelines on de-identification? I understand it was a requirement that they did that within a certain period.
Oh.
And, my understanding is that period has passed. So
that's I did not put that in my slide. Slides. I'm gonna have to add that in. You are absolutely right. In the American Recovery and Reinvestment Act, stimulus legislation, the high-tech provisions that had a bunch of changes to HIPAA also require HHS to do a study of de-identification. And that study was due to be released a year after enactment of the stimulus legislation, which meant that it was supposed to be released in February of 2010. So given that we are almost to February of 2012, it is very, very late. I have no idea when this is going to be released. Right now, the Office for Civil Rights is late on just about everything that they were due to release under high-tech. None of the required studies have been done. The final regulations to implement the HIPAA changes are not released. And admittedly, I beat up on them a fair amount at a recent hearing before a Senate Judiciary subcommittee. I think they are not in sole control of their destiny. There is process that must be observed within any administration, and they can release nothing on their own accord. And so the wheels of bureaucracy are jamming this up pretty good, and privacy is always a contentious issue. I wish I knew when it was going to be released. They are supposed to be doing this study, and in fact, a number of us were at public meetings that the Office for Civil Rights had. I think it was in March 2010 on this issue, where they, invited a number of really important thinkers on this issue to testify. There was a lot of interesting discussion that took place. That report really should be out by now, and there isn't really any good reason why it's not.
And talking about
maybe we can issue our paper
right,
before
so
this other report comes out.
When do you expect your paper to come out?
We're looking at early 2012. Now I'm sounding like a government agency, not pinpointing a due date. We would like to get it published, and so to some extent it may be tied to publication schedules of places where we might want to have it be published. But we are the participants on this webinar got an advanced discussion of some further clarification of these ideas that began at the October 2011 workshop that we had. We're going to try to, before the holidays, pull a phone call together with the same participants to continue to drill down on some of these ideas and refine them even further. And that work will continue into January and maybe even February, but I think our hope would be to wrap it up within the first quarter of the year.
I think you have one more question.
Oh, here we go. Dates hold on, here's another question. Dates like admission dates are really important for research on administrative data, but as part of the 18 attributes. That's right. I am not aware of good models for statistical certification of dates with this type of data. So I'm the presenter and I'm not the statistician, but my impression is that most statistical methodologies that are used by entities that de-identify data, either folks in the academic space who do it, or within companies, that they have to have dates, so they definitely have the dates in the data set and yet still can statistically certify that it raises a very low risk of re-identification. And I always thought that one of the reasons why the statistical methodology was very popular among health services researchers is because you can still include the dates. Of course, you can also include dates in a limited data set. Now, you're right that it's not part of Safe Harbor, but of course, if we were to expand Safe Harbor options and have other methodologies that have been sort of vetted to achieve the very low risk standard, and can be used in a way that merits Safe Harbor treatment, then we might be able to expand on that and have capabilities for people to have dates in a Safe Harbor data set. But we don't have that now.